This week, the Supreme Court will hear oral arguments in Donald Trump's ballot eligibility appeal. The justices will review the decision of the Colorado Supreme Court, which ruled against the former president in December, citing the 14th Amendment's insurrectionist ban. Formal challenges to Trump's candidacy has been filed in at least 35 states. Here's how our next guest frames this historic moment. That the Supreme Court needs to hear this case speaks to the complete failure and moral bankruptcy of the GOP. The fact that the case is unusual does not mean that it is difficult. The plain text should win the day. Back at the table with us, Mark Elias. He's founder of Democracy Docket and a partner at the Elias Law Group. Welcome, Mark.
But tell us how you really feel, Mark Elias, about the position of Republicans. Right. Let's get to the politics in a second. The first thing I want you to do, because we've all had February 8th marked on our calendar for oral arguments, can you pull back the curtains and give us a sense of how one prepares for something like that? What is happening today, this Sunday, to get ready for February 8th?
Sure. So I've argued 4 cases before the U.S. Supreme Court. I had the pleasure of winning all 4. And I can tell you from my experience, what the advocates are doing right now is 2 things. Number one, they are doing a lot of moot courts, which are basically just mock arguments, right? They are pretending that they are before the Supreme Court. They have lawyers who are experienced in this field, pretending they are justices, and they are just answering questions to get a flavor for the different perspectives that the justices may come at them with. The second thing they're doing is they are honing down their arguments. You know, the fact is...
Because there's been a high volume of amicus briefs here.
Right.
There has been a high volume of amicus briefs. There's a high volume of things you can say. But the fact is you get a minute or 2 to say to the court what you really want to say, and they're figuring out how do they tighten down that minute or 2 to make the point they want to make at the beginning.
How does the court read the fact that, you know, to the point all these amicus briefs are coming in, that clearly this is energizing a lot of conversation? Does any of that have any sway or influence on them, you know, from your experience in front of the court, or do they just kind of take it all in and process it with a mind of what they want to do or where they think this should go?
Yeah, so I think you can put the amicus briefs into 2 categories. There are and this is not to disappoint any of the people who filed amicus briefs, there are the amicus briefs that are basically just rehashing what the parties are saying. And I think the justices there, you know, sort of take them for what they're worth. But this case is kind of unique in that you have a series of amicus briefs that have been filed by conservative jurists, by conservative former prosecutors, members of Congress.
Yeah, you've got Mark Roscoe and Christine Todd Whitman and Bill Weld, former Republican governors.
And I think those do make a difference for a different reason, because they are offering the court a breadth of perspective that takes this out of the usual box that cases are in, which is you have the usual suspects line up on one side or the other.
I still come down to this point that I just think that this case for the court is one where they go, it's just not ripe enough. I mean, you know what I'm saying? It's just like we talked about this before. I just think that the court has the political downside in making the decision is far greater than the constitutional upside in deciding this matter at this point. I mean, how do you see it if that's the case? The court may just say, find a quick off-ramp, you know, and it's okay, it's just stay on the ballot. This is not ripe enough. It doesn't mean that we believe you should or shouldn't be. Just leave it status quo ante.
Right. So, look, this is, I think, the great trap that the court needs to avoid. The fact is that this is not a complicated case, and the way the court avoids being political is to rule on the merits, right? The way the court gets itself in the political thicket is by deciding it's going to take into account the political thicket. This is a very straightforward case. The Constitution says that if someone took an oath of office as an officer of the United States and engages in insurrection, they are disqualified from being in office again. And Donald Trump was the president of the United States. That is an officer of the United States. He took the oath of office and he engaged in insurrection. The least political thing the court can do right now is to just follow the Constitution. Once it gets itself engaged in how do we avoid, you know, the partisans being unhappy, or how do we avoid controversy, that's where it gets itself in trouble.
There was an argument, Chuck Rosenberg was with us on the show last weekend, and he made an argument about a potential off-ramp for the Supreme Court. Take a listen.
From holding office, not from running for office. And some of the judges who've already tried to answer these hard questions have seized on that.
That distinction between holding office, running for office, if they choose to take that off-ramp, right? If they say, go ahead, let this proceed, let's see how the election plays out, that seems to me to be more politically fraught on the back end than it is to make the decision now.
Oh, much more so. First of all, I have a lot of respect for Chuck, but here's the problem with that. That's like saying that a 17-year-old could run for president, that the state of Colorado needs to put them on the ballot. And it is only if they win the presidential the presidential electors that at that point they get disqualified, right? The qualification of people to run for office is integral to what states do. But to your point, I think, this would be a calamity if Donald Trump is allowed to run for president because the Supreme Court punts. Then, God forbid, he were to win the election, and then at that point we wind up back in the Supreme Court.
Well, and not only do we wind up back in the Supreme Court, we wind up back with an invocation of the 20th Amendment, where all of a sudden we're talking about the vice president potentially stepping into that role.
It becomes a much, much more complicated case legally, much more constitutionally fraught, and for people who are worried about the politics, it becomes political.
So the reason I bring this all up is because doesn't that then need to be part of the court's calculus?
I think what the court needs to do is play pitch and catch here. There are not...
I have no idea what that means. Explain to me.
So, look, there are cases that are novel, but novel is not synonymous with hard. Okay, the fact that it doesn't come up very often that a president of the United States engages in insurrection is a good thing. But it's not a get-out-of-jail-free card or a get-on-the-ballot card, right? The fact is that the Section 3 of the 14th Amendment, its plain text is clear, and the Supreme Court should just follow that plain text. There are plenty of other terrible Republicans who can take Donald Trump's place. Believe me, if you're looking for a party full of pro-insurrectionist, anti-choice, bigots, they got lots
of litter.
It's like pick dealer's choice on who else they could put on the ballot other than Donald Trump.
But that's part of the strategy also that I think is people lose sight of, that Trump from the very beginning made it very clear this is about deconstruction of the administrative state, of which the court is a part. And so having these cases being brought legitimately against him, he has very effectively pushed the judicial institutions as well as the political class into a space where they're wrangling now. And to your point, Alicia, the politics tends to be the dominant player or will have an impact on the outcome. So Chief Justice Roberts' view is try to dial some of that political pressure off of the court, because he thinks, and I believe rightly, that the court needs to be free of that to maneuver. Do you see these delays that are taking place, that this effort to sort of drag this process out, does that drive some of this for the court as well, in terms of their ability to sort of put the pressure on the system to just bring the case so we can get through this?
Look, I think that you put your finger on something really, really important, and I hope everyone pays attention to this, that Donald Trump thinks that running out the clock is putting pressure on the judiciary to help him electorally, right? I saw the poll that you were discussing just before this, and Donald Trump sees those polls, and he is putting maximum pressure on the judiciary around timing to try to run out this clock. And it is the job of the judiciary not to allow itself to be used in that fashion. I certainly hope that the D.C. Circuit moves more quickly and starts to rule on the immunity question. But the fact is, former Senator Ted Stevens went to trial as you recall, in the weeks before his midterm election. There should be, we need to not allow Donald Trump to create an artificial deadline, an artificial timeline, whereby if the courts don't act, somehow he is done.
He's done. Yeah, stick around. We want to talk to you a little bit more, Mark, about a whole host of things. After the break, we want to discuss Special Counsel Jack Smith's legal smackdown against Donald Trump in the classified documents.